Good. Right. So sometimes I wonder if you think that doctors actually should have magical powers, that we can see all sorts of things, and that you worry about that, you non-doctors, and you're so worried about it that you really feel you've just got to knock us down completely off our pedestals and back in the gutter where we belong. One of the things that I see over and over in decisions, medical legal reports cannot tell who or why or where the torture occurred, and therefore they can tell us nothing about torture at all. It's like saying, if I'm looking over here, I don't know what's behind me. Well, I'm not looking behind me, so how can I know? But I think there's a bit more to it than that. I'm going to unpack it further through the course of this talk. But it's interesting that it was already been raised in the earlier session. Does the absence of an opposite medical expert in asylum cases lead the decision maker to form their own clinical judgment? And this is something that I do worry about, and whether that is one of the reasons why the bar keeps rising for medical evidence. Well, we've already established asylum law requires a very low standard of proof, and that's enshrined paragraph 92 of the Istanbul Protocol. There's an even lower standard of proof, which is also currently a very hot issue for us, and that's for torture survivors rooted into immigration detention. They don't even have to have the level of proof required for an asylum decision, just a concern. And yet the numbers keep increasing, despite the UN Committee Against Torture Fifth Report 2013 saying that this barrier should be lowered for torture survivors. That's, I'm sorry to say, not evident in the new template that's currently circulating for Rule 35 reports. So this goes wider than just asylum decisions. Myths and legends. We already heard about some case law. I'm going to look at some other case law which I see frequently cited in asylum decisions, which is frankly outdated and often clinically just wrong. But I'm going to talk first more about the principles of the Istanbul Protocol, how they become subverted by the clinical judgments of non-clinicians. And I'm going to do that looking at some research that we've done at Freedom from Torture. First, though, just a brief note about body of evidence. This was the report we produced in 2011. And it demonstrated, by looking at decisions mainly in the tribunal, that medical evidence was being assessed inconsistently, not just by judges, but also by the Home Office, and that this was having very significant consequences with critical failures of protection and right to rehabilitation. As a result, what did we get out of that? Well, we got a spot at the first-tier tribunal training for immigration judges, and over the last 3 years, I've trained, I think, every single one, I hope, or almost all of them. And that training session has included myth-busting, the idea that doctors believe everything they're told. I'm sorry, we don't. We also discussed who can make psychiatric diagnoses. You don't have to be a consultant psychiatrist, and they've all been trained on that. And we looked at the effects of trauma on memory. So all the first-tier tribunal judges have had that in their training. We also, with Helen Bamber Foundation, worked on a new asylum policy instruction for reports from the two foundations. I've highlighted just some of those key points that are laid out in this asylum policy instruction on how to assess this medical evidence, that the foundations have recognised expertise, their clinicians are objective, it's not just a report about credibility. Case owners must not make clinical judgments, they must remember that low standard of proof, and they should not dismiss or give little weight to the claim of torture with the Medical Foundation or Helen Bamber Foundation report. But what we're seeing, unfortunately, is the reports are still being challenged by decision makers. The Istanbul Protocol standards are repeatedly questioned, and in particular, paragraph 105F, where we consider the possibility of fabrication, which, as I said, is part of 101 basic medical education. We don't believe how much you say you smoke, we don't believe how much you say you drink, and we certainly don't believe that you got that infection from sitting on a toilet seat. So I don't know if it's just projection that you want doctors to believe everything you tell us, but sorry guys, we don't. So let's come on to these self-infliction by proxy allegations and deal with those specifically. In fact, the allegations predate the KV case law by a number of years. And in fact, the prevalence was increasing in cases we were seeing at Freedom from Torture before KV, and I decided to audit the heated metal object burns cases that we were seeing. There was also that infamous letter from the British High Commission in Colombo, But over years, we've seen a number of references to indecisions about self-infliction by proxy, the torture factory, the scar factory. Is it in Joseph Camp? Is it in Moscow or the Balkans, East London, Croydon? Where is it?
Bromley.
Oh, is it Bromley now? It's been in Handsworth too. It moves around. It's obviously like a bus somehow. They drive it around. That's the text of that famous letter that many Sri Lankans who claimed asylum abroad inflicted wounds on themselves. And versions of this allegation we've seen occurring in multiple asylum decisions made by both UKBA, as it then was, and immigration judges, saying that they knew that determined asylum seekers may arrange for scars to be inflicted. They do not lightly reach the conclusion, but they come firmly to it, and they feel that people are set out to provide this evidence. So what did I do? I looked at 2010 and 11 cases initially. That's where the report was written in those years, because I think that it's more helpful to look at a whole group. If you're questioning something, it's clearly not just happening one time to one person. It's a practice, it's a business. Somebody's making a lot of money doing this. So let's look at a whole group and see what we can identify. And as the Istanbul Protocol tells us, let's make an overall assessment and not just go on a single lesion. So let's think about whether there might be evidence of collusion and what that might look like. Would there be a different profile in the victims? I think we need to be honest. The idea of secondary gain has to be considered. If you're leaving an area of poverty and conflict, possibly gaining access to jobs, education, healthcare, how far would you go? Would you go this far? Fabrication allegation really suggests to me insider knowledge. Now, there is case law about returning Tamils being at risk if they have scars that could be readily seen at a checkpoint indicating previous combat experience. So putting myself in the head of the businessman who wants to make money from this, I think I'll put the scars somewhere where the person couldn't have caused them themselves, make them really big so no one would believe that anyone would consent to pain and disfigurement, and that'll get people asylum. But there were no precedents for this. Combat scarring doesn't look like that. There is no minimum number of scars that automatically wins you asylum. And we know that asylum is often denied to torture victims if it's deemed they're at no future risk. You can be dying of HIV, cancer, renal failure, you still don't get asylum. So where would you get this idea that this would be helpful? So taking a more rational approach and looking at these cases, in those 2 years we had 106 medical reports and 31 of them documented burns from heated metal objects. I looked also at the previous research. When you want to ask a research question, you first of all think about what's already known. So we know that heated metal object burns have been going on in Sri Lanka for a long time. Freedom from Torture, when it was Medical Foundation, we're looking at this in the 1990s. IRCT 2004, 2007, 9% rate. I also looked at other countries that we're recording this information in and found that it was occurring in Uganda and in Iran, for example, but in small numbers still. Suddenly we get this big increase. So we want to think about possible collusion. Do they all come from the same solicitor? I didn't say that. Do they come from the same town, the same job? Were they all in the same camp? Are they all giving the same story? Then I looked at the background. What characteristics in forensic medicine do we know about fabricated injuries? Well, we know that they tend to be very superficial, scratches and abrasions. On parts of the body you can access readily yourself. They often tend to look the same. And the account of the events doesn't fit the clinical findings. I also audited cases from Freedom from Torture where we thought that the injuries that somebody was saying were torture didn't match the history. So, for example, traditional medicine scars, little ritual cuts with a razor blade being attributed to torture, or a little bit of pigmentation on the knees being attributed to torture. These are the sorts of things that we were finding in cases where the doctor did not believe the person. And in contrast to that, we have the characteristics of torture injuries, varying depths and severity, different injury types, different modes of causation, no sparing of clothed body parts because the victims are often partly or fully naked. And we look also at congruence between the account given, the clinical findings, and the timeline. So these are the sort of factors that I found in reviewing that group of Sri Lankan cases. They tended to have a complex torture history. 41% had been detained more than once. There was good clinical congruence, and there were a number of scars that they pointed out as not due to torture, which we take as an indication that they're not exaggerating, they're not seeking to put every scar on their whole body as down to torture. We also found that they tended to have a lot of other scars due to torture that were not burns. A lot have been sexually assaulted, and there's a big psychological impact of the torture, with a high number of people with post-traumatic stress disorder symptoms, and a lot of them already independently in treatment because they're so unwell mentally. So you can build a sort of typical case profile. Now, this is not to be used as a checklist. It doesn't mean that a genuine person can tick every box on this line, and it doesn't mean that if you can't tick every box, you're not a torture survivor. One of the dangers of producing a profile like this is that people will abuse it in that sort of way, but it's an indication of how to assess things. And what I did also was to cross-check. So if one of the factors wasn't in a particular case, well, how many of the others were? And it tended to be many. So if they did come from the same solicitor, the burn pattern and the torture history would be really different, or the detention centre might be the same, but other things would be different. I also wondered why heated metal object burns when, if I was going to fabricate torture, cigarettes are so much more available, so easy to use. Still painful, still look like torture. We weren't seeing the same questions raised so frequently about people who had torture burns from cigarettes. It's a really odd, upside down sort of idea about the evidence. So looking at KV, I think it just asked the wrong damn question. Can the analysis of a single scar tell us by who or why it was inflicted? Well, no, it can't. But analysis of all the clinical evidence of an individual can tell us a lot more than one lesion in isolation. An analysis of a group of cases can tell us more still. And again, we come back to the good old Istanbul Protocol, which already told us that that's what you're meant to do. So in summary, I found no one single factor which could identify a true victim from a fabricator, but I did feel that you can make a balanced assessment of all the evidence and make a reasonable likelihood assessment about your conclusion. But focusing on the single factor to the exclusion of other evidence tends to distort decision making. This issue of lack of congruence is a really important one because it is about the expertise and experience of the examiner as much as anything else. So if the patient says they beat me with iron rods, and when you look at them you find burns, and the burns seem to be curved, it makes you think, oh, this doesn't add up. Does that mean they're automatically fabricating? That's a possibility. There are other possibilities. So think about the contact time required to cause a burn, the pliability of heated metal. How do people make stuff with iron? They heat it so they can bend it. And you listen to the patient. Human skin is not cowhide. You don't need to do it like this. And burns are not potato prints. This is not how it happens. How long does it take metal to cause a burn that will blister? Well, fantastically, as they used to do in the 1950s, they studied this. They got a bunch of rats. This was in a good cause, I have to tell you, so don't worry too much about the poor little rats. It was to improve safety standards in metalwork industries. A bunch of rats, and they burned their ears. And they measured the temperature of the implement used to burn little ratty ears with the time taken to cause a blister. Not very long at all. So if the metal is glowing red, is it 70 degrees? No, it's 480 degrees. How hot could you get your poker if you put it in the fire? You can get it really, really hot. So I don't have the figures because they didn't do this with the rat ears. I think the rat ear would have just melted away completely. But you can just see that I'm sure someone somewhere will be able to produce a graph which shows you the infinitesimal contact time required to blister human skin. I'm now going to move on to more recent research that I've looked at, freedom from torture, and this is an audit of response letters that we've been asked to do. And I wanted to focus initially, because there were unfortunately quite a lot, I thought I would look at those where the UKVI decision was made after January 14, when the new API came in, supposedly setting these wonderful new standards by which they would make their decisions. So I got a group of 24 cases where the decision is made in 2014. I wrote a response letter and I know what happened to it. So of these, 12 got asylum following the response letter and 12 were refused. Slightly more of them were pre-initial decision, 10 were fresh claim. And you can see that it looks as though things are pretty bad for you if you're fresh claim. Now, these fresh claims usually have had no medical evidence beforehand. but they've clearly got a very weighty loss of credibility in their file, and this seems to be making it very difficult for medical evidence, even if it's the first time it's been heard, to actually turn things around. It also looks from this admittedly very small sample as though Liverpool's not the place to get your decision made, but maybe we'll need to talk to the Home Office about that. And I looked at the different factors in these decisions against those standards set out in the API. So, for example, both foundations are accepted as having recognised expertise. 30% of these decisions made negative comments about the doctor's qualifications. They all made a lot of negative comments about the methodology of the medical legal report or the interpretation of the findings. Very common was taking issue with the consideration of other causes of the physical lesions, with the assessment of consistency, and the objectivity of the doctor being very frequently questioned. They all made multiple clinical judgments, and this is despite the API very specifically saying, don't do this, not your thing. They do it. And one of the commonest ones that they do is they challenge the clinical assessment that's been made of the link between the psychological evidence and the torture, and they prefer other causes of the physical and psychological injuries. They also take issue with multiple other things, as you can read there, with late disclosure, with why you're not in treatment. If you're not in treatment, you can't have this illness, and so on. And there's a lot of errors basically in law. I don't want to go too far on this because obviously I'm not a lawyer, but seems to me pretty blindingly obvious. They fail to give appropriate level of weight to the medical evidence. They continue to apply negative credibility findings to dismiss the medical evidence. And they fail to consider the physical with the psychological evidence in relation to the torture account. So what we see in these UKVI decisions is they go through the history of the detention, they look at the medical evidence about physical lesions, they knock that down, and then they say, therefore, we don't believe you were detained. Then they go on, blah, 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 blah. They finally come to, can we risk returning you? What about your mental health? And then they bring in the psychological evidence, but they don't include that psychological evidence that is also actually going to the weight of evidence corroborating the torture account. And this is a really important failing. I also want to talk about case law very briefly if I've got time, so I'm going to move on. But basically, in summary, these 2014 decisions that have been returned to us for responses show repeated and multiple breaches of the API, especially the use of clinical judgments and a failure to give appropriate weight to the report. But they also frequently cite outdated and wrong case law. And as we've already heard, there's some good case law out there which tells them how to do it. But instead, I'm sure you've all seen this a million times, HH. What does this say? It confuses the credibility assessment with the doctor's obligation to assess fabrication and accuses the doctor of trespassing on this. And it confuses the use of consistent in its non-IP sense and suggests that there's no higher level of corroboration of the account than this, which seems to ignore completely that paragraph 187 exists and that the doctor has almost certainly given it some attention in their report. There's another problem with HH, again, a very popular paragraph to copy and paste into your decision if you're a little UKVI person, and they go on about the doctor's not a psychiatrist. But we've already established in the API that reports from the foundations have their own recognised expertise. We've also established in the first tier tribunal training that you don't have to be a consultant psychiatrist to make a psychiatric diagnosis or give that opinion. There's also, again, a repetition of this idea that it's just a repeat of the account given. And again, HE is also trotted out to say that doctors just repeat everything they're told. And as I've said to you, well, this is not what we do. And the FTT, the first tier tribunal training, has reiterated this, and the API says that these reports have expertise which needs to be recognised as independent. Sadly, the upper tier message hasn't quite got through. The James Jones decision, which came out in July, August this year, refers to a requirement for specialist training for physical evidence of scarring. Sorry, that's a typo. That doesn't exist, and it seeks to discard the psychological evidence given by a doctor who's not a consultant psychiatrist. Very briefly, AEFE, again, constantly copied and pasted into decisions, and it says this bizarre clinical judgment, really, in the case law that conflates post-traumatic stress disorder with depression. They're not the same thing. And just because something's become more common doesn't automatically mean that it's a fabricated condition. It might just mean it's become more common, or we're recognizing it more clearly and identifying it more often. WT, another one that gets copied and pasted in. Again, this ignores the fact that the medical legal report should be regarded as expert evidence. It disregards the IP meaning of consistent with and the expert assessment of levels of consistency. And it disregards the assessment of relative likelihood that report writers are now making according to good forensic practice and RT. It suggests a higher level of consistency is required to substantiate evidence of torture, which is raising the standard of proof and ignoring, if you like, paragraph 161 of the Istanbul Protocol, which reminds us that many forms of torture leave no scars at all. Worst of all, P. Yugoslavia. I don't know anybody who knows this case. I couldn't track this down. This is the paragraph, the first bullet point, which is pasted in and said to be P. Yugoslavia. The report is not proof of when or by whom the injuries may have been sustained or why they were caused. P. Yugoslavia is a psychiatric case about PTSD and risk of suicide on return. There is no physical evidence in this case. Why are they doing this? They're just putting it in from somewhere and calling it case law when it isn't even case law. And there are a number of other things. Again, I've just pasted these in. They're in multiple decisions, and they, again, are contrary to the API that the Home Office have signed up to. Reports are expert and independent. You can't say that they're not. The wrong standard of proof is used. The diagnostic level of evidence is not required at this stage. Some of these sentences, I tried to track them back using good old Google and everything else I could find. I found some of them are quoted in Asylum Aid's fantastic publication, Still No Reason at All and No Reason at All. So they go back into the mid-90s, but still no case law, still being copied and pasted in, and yet they have no basis in this decision making. So these are the sort of abuses of our medical evidence, this by whom, where or why, the use of case law to argue that medical evidence has failed to do something and can therefore be discarded, even though that's in any event outside its scope. We can't tell you what colour uniform the guard was wearing, or the name of the prison, or the particular motivation of the torturer when we're examining an individual for evidence of torture. But what we can give you is an overall evaluation of physical and psychological evidence in the context of what is known of other possible causes of such a clinical picture, and give that expert opinion on the likelihood that torture occurred. Second abuse of medical evidence, 187 and RT. I just don't think the case owners understand this at all. They use it to argue that other causes can be preferred, even when the report clearly assesses relative likelihood. Even though the burden of proof is so low that consistent with is still evidence of torture, they're saying that it's not, and they overrule the doctor's opinion. The third one, fabrication, using the doctor's very specific consideration of paragraph 105 on fabrication to dismiss the medical evidence as a whole on the grounds the doctor has considered overall credibility, and therefore they've gone outside their boundaries and we can throw the whole thing in the bin. Still seeing this abuse that we're not a proper expert, there are incorrect assertions about medical qualifications, training and expertise. Doctors believe everything they're told. Well, I think I've made that point clearly enough, but this loss of credibility elsewhere is used to deny the medical evidence and to accuse the doctor of not being objective and believing things without question. There's a lot of confusion about this consistent in the IP 187 sense and consistent in its dictionary sense, and it is really hard not to think sometimes that this is being a deliberate perversion of what was going on. And it raises the bar very often to the diagnostic level when that's not required. So how the bar got higher? Well, I think these myths in outdated case law are very much to blame. Legends that get repeated without citation, without question, a failure clear to implement the standards of the new API and to understand and adhere to the standards of the Istanbul Protocol, and bizarre paradoxical expectations of what doctors can and cannot do. So I'm just going to leave you at 3 more slides. Give me my minute. In countries where asylum seekers are examined to establish evidence of torture, the reluctance to acknowledge claims of torture may be politically motivated. The Istanbul Protocol also got ahead of us with countertransference, avoidance, withdrawal, defensive indifference, anger or repugnance can arise in people doing this work and may prejudice their ability to make an objective evaluation. What are the implications for practice? One question, who is an expert? How should non-IP compliant reports, such as a Rule 35 report, be assessed? And does the disconnect between medical evidence and legal conclusions about it lead to loss of confidence in professional expertise? If there's no opposite expert and no cross-examination, does the decision maker take on these roles and then become led to make clinical judgments in a way that just would not happen in other settings? Thank you.
So I want to pick up this idea of looking at psychological evidence also, particularly also in a broader context. And Juliette's talked about setting a setting of a broader context of experience that's built up overseeing a number of people and having a clinical understanding of what's possible and what isn't, and what makes sense and what doesn't. And I'm going to do that by looking at the way in which psychological information, let's broaden out a little bit, can contribute to what Stephanie was bringing up earlier about credibility assessment. And again, just a little caveat before I get going. Yes, I and the colleagues that I know in this room, most of whom I do, know that we are not making credibility assessments. We know that that's a legal judgment for a decision maker to make. It's a legal assessment that they work through and make. It's an incredibly difficult one, and I'm really pleased I don't have to make it, and that's not part of my job. But what I can do is offer information which will give the possibility of different hypotheses to the decision maker on which to base their fully considered credibility assessment. So we could pick examples of credibility assessments that are from any number of reports and from Juliette's work. But I've taken these from our study of assumptions made by first-tier tribunal immigration judges, which we published this in 2010, so briefly before then. And I've just pulled out these as examples that I'm going to use in the next few moments. Firstly, there's an assumption made in here that by the judge about memory and how memory works. And particularly, I would have expected a raped person to know when they were raped. That's a dating issue. There was another assumption that I want to look at on consistency, which again has been mentioned, as Juliette says, for years and years and years, which is quite frustrating. But anyway, this was a positive decision on the basis that the appellant was able to withstand a cross-examination that lasted for over 1 hour without any serious discrepancies come to light. And that is an assumption that meant that account was true, rather than made up. And finally, on disclosure, if this had really happened to her, she would have disclosed it earlier in the process. Forgive me while I just change the order of my slides. So, yes, you can have a medical legal report which looks at that particular person and the issues that particular person has. But let's stand back for a moment. What do we actually know already? How does memory work? There's a massive, horribly massive literature on how memory works. So here are some particular studies that talk to those particular points. Quite an old study, 1995, there was a study where people were asked to record for 3 months medical events, health events. So what medications do you take, when did you go to the doctors, minor illnesses and so on, and people actually kept a diary. And then they were interviewed at the end of that 3 months, and they've manipulated some people straight away, some people 3 months later. And first of all, they were just asked on a free recall, how many health events do you remember that you recorded in your diary only 3 months ago? People remembered 47% of the events that they had written down 3 months ago. Okay, of those, can you remember the date when they happened? And what's really interesting here is that the researchers set a threshold for what they called accurate. And their threshold was to within 2 weeks did they get the date right. Not within 1 day, within 2 weeks. And 50% of those recalled events were dated correctly, i.e. within 2 weeks of the correct date. So that's a little bit of a baseline of memory for dates. Looking at inconsistency, we did a study ourselves, and we showed that and I have to say this fits in with the broader literature which shows the same thing, but we particularly looked at asylum seekers and refugees and found that if you interview them twice and you ask about the peripheral minor details of a traumatic event, 42% of those details will change between the interviews. Looking at disclosure, a different study by Diana Bergner showed that difficulty in disclosing torture, including sexual violence experiences, the difficulty of disclosing that in a Home Office interview was significantly related to levels of symptoms of PTSD, specifically of avoidance, depression, levels of shame, and levels of dissociation in that interview. So we know some things about these assumptions that are being made in decisions. Don't need to be assumptions. They could be based on actual scientific literature. And going on for that, I want to pick up the point that in each of these studies, sorry, just to flick back a moment, these studies, these people were not diagnosed one or the other. Well, the first one, they were not a clinical study at all. These were looking at levels of symptoms of. And so one thing I suppose I'm urging you to do is to go beyond the diagnosis of PTSD, of depression, and think, well, what does that mean if someone's has certain symptoms of these psychological difficulties? The actual symptoms themselves will have an impact, even if they don't hit all of the numbers and the different combinations of symptoms that you have to hit the diagnosis, to go over the threshold of the diagnostic criteria. If you're being interviewed and that interview is triggering you to re-experience a horrendous event with all the emotions of that moment, then you're not going to be able to present very well in your interview. You might be dissociating, and indeed we found that in Diana Bergner's study, that there were very high levels of people being dissociated. They're not actually connected to the conversation they're having at all. Avoidance is a symptom, but it's also going to impact, obviously, on your ability to give credible evidence in an interview or in a court. Persistent negative trauma-related emotions is a mouthful that DSM-5 has introduced in the PTSD diagnosis. So shame is there, also guilt or anger. Not being able to concentrate comes up in PTSD and depression. And again, that's having an impact on how you can present yourself as credible and coherent and whatever the asylum system expects of you. Overgeneral memory I've included just to, we found evidence in other studies that I don't have time to go into, that depression is not being seen as an important consideration when someone's presenting a case for asylum. Depression has been shown for 20, 30 years now to be associated with what's called overgeneral memory. Briefly, if I give you a cue word of pretty and say, think of a time in the past that a memory that sparks off for you, hopefully most of the people in the room will be able to say something like, oh yes, I went for a walk last week in the park and the trees were very pretty. If you're depressed, you will be much, much more likely to say, trees are very pretty. I like going for walks in parks where there are pretty trees. You won't give a specific date and time. So, summing up, using this quote from John Barnes from 2004, he made the point that where there's an asylum decision being made, it's drawn on taking an account of past persecution in order to assess a well-established fear, that's not the right word, of a fear of future persecution. And he said that when you look at country evidence, which is one of the areas of evidence that you can test that account against, in country evidence you can compare this particular account against a breadth of evidence of looking up Amnesty International reports or what you read in the papers, whereas as a decision maker you have a medico-legal report but you have no general context against which to judge whether it fits and whether it makes sense. So I hope I've very, very briefly suggested that there is a context. As Juliet says, there's the general context brought together of experience of experts and looking at cases away from just the one individual. But there's also a whole scientific research, a body of literature, a body of research that can also be brought into this thinking.
So I've got 10 minutes. I want to make roughly 10 points. We've already heard quite a lot about the case law and medical evidence in the United Kingdom and elsewhere this morning, and so I don't propose to repeat that territory. It's very well set out in my colleague Stephanie Harrison's excellent paper, and I might also commend to you the new book advertised in your conference packs and available in all the better bookshops, Immigration Appeals and Remedies Handbook by myself and my colleague in Chambers, Peter Jorro. And we have excerpts on medical evidence in the conference pack. The first point, the doctrine of ultimate issue lies at the bottom of a lot of the discussion and perhaps the different perspectives between the judiciary and doctors on the role that should be attributed to medical evidence. And the doctrine of ultimate issue is essentially that matters of credibility and risk are ultimately issues over which the court is sovereign and makes its decision based on an evaluation of an asylum seeker's account, read with country evidence, read with medical evidence. And so we always have to be careful of not falling foul of the doctrine of ultimate issue. And for that reason, it's always important that doctors, I think this is right to say, concentrate on explaining why, in their opinion, an account is plausible in the light of a patient's presentation, rather than stating it to be credible. Ultimately, it's a matter of technique as opposed to language, but that essentially is the distinction that's to be drawn. Secondly, the Istanbul Protocol, for all that it may be, partly responsible for an arms race whereby judges expect ever more detailed reports, is nevertheless a key document in terms of how to produce reports. And the closer your report is to the standard of the Istanbul Protocol, then the less space there is for a judge to depart from it. The more cogent the reasons they would have to give to depart from a report which is highly compatible with the Istanbul Protocol. Bear in mind that essentially the help that a doctor can probably give an asylum seeker in expressing a genuine medical opinion is going to be concentrated on a mixture of physical and psychological presentation, and it's going to be addressing the asylum seeker's case, which insofar as its truthfulness is to be evaluated, depends partly on their presentation, and it depends partly on a critique already made of it, usually by the Home Office, or due to be made of it by the Home Office. And the main points that the Home Office make, to which a doctor might provide an answer, I imagine, relate to discrepancies and to the asylum seeker's behaviour. And so, the doctor should be looking carefully at whether or not there are already discrepancies in the account or bits of behaviour, failing to claim asylum in a timely fashion, failing to leave a country speedily enough, any form of behaviour thought inconsistent with the possession of a well-founded subjective fear of persecution. All those kinds of things are where the doctor's measured opinion can be most useful. In any expert report, the expression of doubt can sometimes be useful because it makes the author look more independent and nuanced. And the good thing about the Istanbul Protocol, with its famous calibration of opinions, not consistent, highly consistent, typical and diagnostic, is hugely useful for that reason, because it automatically allows the doctor to, give an opinion which appears measured, and no doubt it is measured. It's very important the doctor carefully explains why they prefer the history of the client to any alternative possibility, such as other causations of the medical presentation. So they're the first 4 points, really, in terms of the key criteria for doctors to bear in mind when writing their reports. If you're commissioning a report, on the other hand, 2 important things to bear in mind, I'd suggest, are always read the doctor's report critically against the authorities to which we've all been taken already today. And I emphasise critically. Many doctors' reports are detailed, cite authorities, cite the Istanbul Protocol, but nevertheless could easily be shot down by typical Home Office submissions or cynical judicial determinations. But the points I've already made about inadequate reasoning and that kind of thing are essentially what to be looking for. And for that reason, I would suggest it's important always to bear in mind that despite the tendency of everyone in this field to leave everything to the last minute, and that that includes judges, it was a good idea to factor in time for the amendment of the report, because even though, of course, the expert witness directions tell us that expert evidence should be uninfluenced by the exigencies of litigation in hand, nevertheless, the reality is that anyone who's any asylum seeker is entitled, to the best medical report, the truest expression the most accurate expression of the doctor's opinion, and the public, who are often paying for these reports, are also deserve that a genuine opinion isn't lost in value because of an inadequate expression. Point of law and onwards appeal. As we've already touched on today, Istanbul Protocol is the pinnacle of a jurisprudential approach to medical evidence. It's endorsed by UNHCR, and thus under the recitals of the Qualification Directive we must take it as part of the standard repository of European Union law of status determination. It's regularly cited by the Strasbourg Court, and so you have both the supranational courts essentially focusing on this document. I'd suggest that any judge who doesn't give it the clearest of attention and engage in the greatest detail in departing from such a report has erred in law. And there's no question, it's certainly not a question of perversity. It's a question of whether or not they've given a detailed and reasoned engagement for departing from an Istanbul Protocol compatible report. We heard about NA Belgium and RC Sweden earlier. Obviously, RC Sweden is a case where the Strasbourg Court says that Sweden was wrong to discount an asylum seeker's story when he had a pretty poor quality medical report, but the government had nothing. As I read the authorities such as NA Belgium, they don't say that doctrine doesn't apply in the UK. They say it doesn't apply at judicial level. It's not for the first tier tribunal to call for expert evidence from the Home Office. So whilst it may not be a terribly helpful case on appeal, it's manna from heaven for your public law challenges. Any clearly unfounded decision that departs from medical evidence without getting expert opinion to contradict it, any fresh claim decision that does the same thing would appear to be unlawful, read with the upper tribunal discussion of RC Sweden. And before I finish, one final public law thought. This is one of the challenges crying out to be brought. Who knows, someone may already have brought it, but not to my knowledge. Time and time again, I see I see the Home Office in declining to accept a Rule 35 opinion as adequately well reasoned and therefore not constituting independent evidence of torture. Time and time again they say that the detention centre doctor hasn't applied the Istanbul Protocol or has otherwise not written a very good report. But given that the state is detaining a vulnerable asylum seeker who ex hypothesi is a torture victim, it's really hitting them when they're down to now have them examined by inadequate doctors. There must be a challenge to be brought on whether or not all doctors in those detention centres have to get some training on Istanbul Protocol, or at least on writing more cogent reports, or at least that any decision maker faced with an inadequate report never rejects torture because the report is inadequate, but rather commissions a second Rule 35 report. Thank you very much. Those are my thoughts.
Yes, so the question of what to answer when the judge asks you a question that you can't make sense of, that's a tricky one. The specifics, I think I answered in my talk that it was simply the wrong question. And when you look at the science and you actually consider what happens when people have burn injuries, you don't need to hold them down that long, and you don't need to have an anaesthetic, and you don't need to suppose that the suburban basement in Croydon or Wimbledon or wherever the Scar factory is supposedly set has to have full anaesthetic facilities. No, this is not necessary.
Thank you. Mark, do you want to add anything to that?
Not precisely. Just on the KV material, I think it would be wrong for someone who sits as a judge to criticise KV. That's a matter for others. Presumably, if the decision is unlawful or procedurally unfair, the Court of Appeal will detect that, and if they don't, we'll have to live with it. But one rather has the impression that KV is an authority that is intended for highly exceptional circumstances. Remember. What's the case? There's a case about tigers they go on about tigers in the Supreme Court. It's a lead case on standard of proof and balance of probabilities, and how it is that there are in English law only two in general standard of proof, beyond reasonable doubt and the civil standard. Though of course they weren't thinking about asylum in that context. And the point they make in that case, Ray H, I think it is they say that the less likely it is that something has occurred, the more cogent the evidence has to be to establish it. And therefore, it is more likely that the large animal seen in the twilight in Regent's Park, in most of the park, is a dog than a tiger. Is obvious, and it would require very cogent evidence, unless you're in the bit of the park where the zoo is, presumably, to conclude that it wasn't the unlikely event. So, and for any judge who's contemplating following KV, they really ought to be directing themselves that for an asylum seeker to have, had their skin punctured by a 450 centigrade needle must be a staggeringly unlikely proposition.
Thank you. And the point about developing standards, helpful point. Anybody want to comment on that?
Sorry to jump in, but given the theme of the day, I just wonder if that's more bar raising. I'm part of there's a lot of people here, we're part of a group of psychologists, and we've had very serious discussions about shall we write guidelines and standards for psychologists writing medical legal reports. And I just speak for myself. I think one of the reasons we haven't is what do we have to do? We have qualifications, we have, and now I'm speaking for all of us, qualifications, experience, expertise, working in foundations whose whole business is understanding this business. We have the Istanbul Protocol, and still our reports are being turned down. I'm not sure that more proving that we're good enough is what needs to happen, to be honest. I think or the Home Office and the judiciary need to say, right, this is what we want to see. We want to see that you've ticked this, this and this box, and when you have, then we'll believe you. Then let's tick the boxes, but I don't know, other than that.
I think that's a fair point. And I think we're also very conscious of not wanting to further disadvantage those people who don't have access to the long form Istanbul Protocol fantastic reports, people who can only access a few lines from a GP. And what I trained with the first tier tribunal judges was that should be given its own weight. If you have only got a brief letter from a counsellor or an appointment confirmation that they've been into therapy, that still carries some weight, and it still should be considered and not thrown out just because it hasn't ticked a box or the author isn't on a specialist register of some kind.
Thank you. I think this is a debate that's going to go on for a wee while, but not this morning. A question here.